So the DOJ, AG Bondi, 25 states, and now multiple 2A organizations have joined to support the fight against statewide concealed carry ban laws. And this challenge is now heading to the Supreme Court for conference this next month. So let's break down what is happening in this critical case. Now, before we jump into this video, I want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, I highly recommend Attorneys on Retainer. They're in a league of their own, they're an actual law firm, and they can help you in cases and potentially even jurisdictions and states that other companies would not. And one of the really cool things about AOR is right now, they've expanded their coverage. You can get things like civil liability coverage, red flag law coverage, and a lot of things if you sign up for their program. And right now, if you sign up using my code ARMEDSCHOLAR, you can get $50 off an individual plan or $25 off of a family plan. So thank you again to AOR for sponsoring this video. As I mentioned in the intro, in this video, I have an update for everyone in states like New York, California, Hawaii, and others who are currently facing attempts to ban concealed carry within your state. The critical case out of Hawaii called Wolford versus Lopez is currently seeking emergency Supreme Court intervention, and the Supreme Court will now have to consider this case this following month at conference. This challenge revolves around a preliminary injunction and the Ninth Circuit, who found that the states here could put in place catch-all public property bans, and to do so would be permissible under the Second Amendment and what the Supreme Court said in Bruin. Recently, to the surprise of many, the DOJ, AG Bondi decided to step up in this case and support this challenge against the state of Hawaii. They filed an amicus brief to the Supreme Court arguing that it's finally time for them to review these carry ban cases which have been passed after Bruin. They also pushed for the court to correct the ongoing lower court defiance, especially after Bruin, and they even mentioned that it's potentially time soon for the Supreme Court to review rifle and magazine bans. Now, if you're not aware, this case is a challenge to Hawaii's new laws on concealed carry that they passed in direct response to Bruin. This law, like others, tried to add more restrictions to concealed carry and create a default rule where individuals can concealed carry on private property that's open to the public only if that owner of the business gives express permission to do so, by doing things like putting out a sign or telling you individually expressly that you can conceal carry at that location. This law in Hawaii made concealed carry even worse than what existed prior to Bruin. Now keep in mind, Hawaii was already a really bad state. They already only had issued a handful of permits over 18 years, and in some counties had never issued a single concealed carry permit. And on review, the district court issued a temporary restraining order, which was then later converted to a preliminary injunction. Now, in that decision, the district court blocked the private property rule as likely a violation of the Second Amendment and inconsistent with Bruin. The court determined that the history did not support Hawaii's inversion of the traditional presumption, where essentially the property owner would have to put out a sign that said concealed carry is not allowed here. This law changed that and said that they had to put out a sign saying that concealed carry is permitted. So it turned that all on its face and made things even more complicated. Now, after that ruling, the state of Hawaii decided to appeal to the Ninth Circuit like they always do. And the Ninth Circuit decided this case along with the California concealed carry bans as well, the SB2 case, which I'm also a plaintiff in. That is the case May versus Bonta. That's still ongoing, but this Hawaii case was heard along with those California challenges as well. And on review, the Ninth Circuit upheld the catch-all property ban and reversed the injunction issued by the district court in this Hawaii case. The Ninth Circuit relied on older restrictions on hunting on private property to support this type of statewide concealed carry ban. After that, the plaintiffs asked for the Ninth Circuit to review the decision en banc, but that was ultimately denied. Now, you did have some judges on the Ninth Circuit, like Judge Van Dyke, who joined other judges saying that essentially their colleagues are disrespecting the Second Amendment and that they are continuing to treat the Second Amendment like a second-class right. And now, ultimately, this case is in front of the Supreme Court. Now the plaintiffs in this case are seeking emergency Supreme Court intervention. They are essentially seeking a review of what the lower courts have said on this issue. Now, this case has a hard road to get Supreme Court review since it's still at a preliminary injunction stage, and it deals with that preliminary injunction, and the Supreme Court typically denies these type of interlocutory cases. Typically, they like final merits cases, and we've had other permit challenges out of New York, New Jersey make their way to the Supreme Court at a similar stage, but they have been denied multiple times by the Supreme Court. However, this one's getting a little bit interesting because the United States, the DOJ, the Trump administration, has now jumped in support of this challenge. Recently, they filed an amicus brief arguing that the Supreme Court needs to take review this case right here and now. The brief of the United States states that the near complete ban is flatly inconsistent with Bruin and the long history underlying it. Bruin recognized that an ordinary, law-abiding citizen has a general right to publicly carry arms for self-defense. Now, one of the interesting things in this brief is that the Trump administration is pushing the Supreme Court to take preliminary injunction review of this, take this case on an interlocutory basis, take the emergency review. And they're saying that they should do that because essentially nothing else needs to be developed at the lower court level. They argue that the state of Hawaii here conceded in the Ninth Circuit that this could be reviewed pretty much on the merits, even though it's not traditionally at the merits stage. But they argued at the Ninth Circuit level that nothing else needs to be developed, no other facts, no other evidence, and that this is simply a legal matter that can be resolved by a court. And now that this is in the Supreme Court, you have the state of Hawaii saying that, no, you need to kick this, send this back down, we need to develop this more. But here you have the Trump administration and the plaintiffs saying, well, you said before in the Ninth Circuit that that was not the case, and therefore you cannot change that. Instead, this opens the door for the Supreme Court to take this case right here and now. They point out that Hawaii in the Ninth Circuit argued that there was nothing else for the lower court to develop at trial and no further evidence was actually needed. This is critical for what Hawaii is now arguing to the Supreme Court, and really it caught themselves in a trap. With this type of position that they took, they really caught themselves in a critical trap. Now, Hawaii responded to all this kind of like most anti-gun states do by saying this is not ready for review yet. There's not a circuit split. Kick this case, delay this. You don't need to review this right now. Let the lower court develop this on the merits. There's more evidence that needs to be developed at the trial, so just don't address this now. They also push back against the Trump administration supporting this case. They say essentially that the United States is an uninvited guest and that their brief should be ignored. And then they also argue heavily that their history and tradition of the state of Hawaii should essentially supersede and override national history and tradition. Now, in response to a lot of this, like I mentioned, Hawaii is trying to use their own state history, their own state tradition to support this type of catch-all public property ban and these type of restrictions on concealed carry. They argue that their state history and tradition should trump the national history and tradition. They state that Hawaii seriously errs in contending that because it has limited the carry of weapons in public spaces since at least 1852, its default rule is constitutional. Effectively, Hawaii is claiming that its tradition trumps the founding. They state that that assertion is self-evidently frivolous. So here the plaintiffs are pointing out that the state of Hawaii has already conceded legally in the Ninth Circuit that for the purposes of this petition, that there is nothing further that can be developed at the lower court level. Therefore, they cannot now argue in the Supreme Court at this petition level that the Supreme Court should punt this case down below to a lower court for further development. The Ninth Circuit relied on the concession made by Hawaii to reach their ruling, and that means that they cannot now simply backtrack those statements now essentially to avoid Supreme Court review. So with the help of the Trump administration, the state of Hawaii might have actually got themselves caught in a trap. A lot of the brief is focused on kicking the case for further development down below. They also do focus on a circuit split not being developed yet, but a lot of it is kick this case, delay this, let the lower court review this more. You don't have to address this now. But that is not what they argued in front of the Ninth Circuit. This case is now gaining a lot of momentum, and now it's currently set for Supreme Court conference on September 29th, which is early at the Supreme Court's next term. So pretty much just this next month, we are going to have this case go to the Supreme Court for conference, and hopefully they determined that they need to review this issue and step in finally on this whole Bruin defiance and these concealed carry bans. So just next month, the Supreme Court will consider whether they want to step in early on this concealed carry issue like the Trump DOJ wants them to, and essentially if they're going to put an end to these whole statewide concealed carry bans and the state defiance that is now developed and happened after Bruin. So we're going to be watching this closely to see how this develops. This is going to be critical for other states that have these type of concealed carry bans like California, New York, New Jersey, and others. So as I get more information, as this develops, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to simply subscribe to the channel. Also, you can check out my website, ARMEDSCHOLAR.com. Over there, we have a lot for you guys. We have the free legal guide that you can sign up for. All you do is put in your email and we email you over a free PDF, and we do some follow-up educational information and emails. And then also over there on the website, we have things like channel merch, and then you can check out deals, coupons, all that. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.